Did you know that making too much noise can cost you 6 months in jail? Let's break it down. I'm Marc Lopez, former prosecutor turned defense attorney. Let's talk about disorderly conduct. Disorderly conduct is a Class B misdemeanor, or it starts as a Class B misdemeanor with a $1,000 fine and or 6 months in jail. Disorderly conduct is actually 3 separate crimes. Let's go through those pretty quickly. The first one is disorderly conduct is when a person engages in fighting or tumultuous conduct. So fighting is obviously pretty easy to understand what that is. You're throwing punches at somebody. It's a physical altercation. We see disorderly conduct get charged a lot when people are engaged in fightings at the bar. Police don't know who started it. Both people sound pretty plausible why they're hitting each other. So you'll see police just charging everyone with disorderly conduct because it just covers any type of physical altercation. Now, the subpart of that same one is tumultuous conduct. Tumultuous conduct is conduct that did or could have hurt somebody. So, throwing a punch and the person blocks it. Well, that's disorderly conduct. Throwing a firecracker at somebody, that's disorderly conduct. Swinging your elbows in a crowded area, that's disorderly conduct because it's tumultuous. So fighting or tumultuous conduct, that is a pretty, I'm not going to say it's very common, but it's something that we see a lot of. It's also a lesser included of battery. It's fighting, but it's not so serious as a felony. So when we're trying to reduce felonies, I'm always throwing out disorderly conduct. Hey, so they got into a big fight, guy broke a bone. Let's plead guilty to disorderly conduct. It's a misdemeanor. So disorderly conduct for the fighting or engaging in tumultuous conduct is a lesser included of lots of other crimes that involve punching, hitting, or any kind of just like rowdiness. So it's a go-to for this law firm when we're trying to negotiate felonies down to misdemeanors. Hey, we always ask the prosecutor to dismiss. If dismissal is out of the question, then we always try to do some sort of disorderly conduct because, again, it's a misdemeanor. It's serious, it's a crime, but it's a whole heck of a lot less serious than a felony. So that's the first one. The second one is when a person makes an unreasonable amount of noise and they continue to do so after they've been asked to stop. So typically we have people yelling and screaming, neighbor comes by, hey, please stop that. Someone's at the mall and they're yelling and screaming, security guard says, hey, stop that. A police officer gets involved while they're doing an investigation and someone's acting crazy, yelling and screaming. Those are all examples of disorderly conduct. Now, for the unreasonable noise, the person has to be asked to stop because they very well may not know they're loud. And we all have these people in our lives that are just loud individuals. I work with you. And they have to be given the opportunity to stop or bring down that level of loudness. So there always has to be, hey, you're being a little bit loud, I need you to bring it down. And if the person continues to do that, well, that can become disorderly conduct. And I cannot stress enough, they must be loud before being asked to stop, and they must continue to be loud after being asked to stop. There's some constitutional considerations we'll talk about in a minute, but that's a second type of disorderly conduct. The third example of disorderly conduct is when a person disrupts a lawful assembly of people. And so I'm thinking in my mind for these type cases, it's going to be town council meetings, library board meetings, where people just will not stop talking out of turn. It's a meeting and they just won't be quiet. And you'll see they'll get threatened with being charged with disorderly conduct, or they can actually be escorted out under the guise of disorderly conduct. So because they are disrupting a lawful assembly of people, it would not only apply to town council or library board meetings, but you can imagine anything where there's a lawful assembly of people and somebody's creating an absolute disruption. So those are the 3 types of disorderly conduct charges in Indiana. Now, for the making an unreasonable amount of noise, well, there's an actual constitutional analysis of this. And it gets kind of complicated for a misdemeanor, but here it is. In Indiana, political speech has a higher level of protection than normal speech. And it's powerful. We want to protect that because we don't want to put down political speech. However, if that political speech interferes with the police officer's investigation or the people are surrounding that investigation to impede on their privacy, well, they kind of touch this level of disorderly conduct. But it doesn't stop right there. Indiana actually has a 2-prong analysis for political speech and disorderly conduct. Let's jump in. First, it must be determined whether state action has restricted a claimant's expressive activity. The restriction of loud speaking during a police investigation may satisfy this requirement. Second, it must be decided whether the restricted activity constituted an abuse of the right to speak. That is some fancy talk that's best understood through examples. So let's do that. We have a lady that is getting arrested, and she tells the officer, stop speaking to me so disrespectfully. Speak to me in a respectful manner. I'm a taxpayer. You're my employee. That's political speech. It's not disorderly conduct. It's not. She's commenting on what's going on. The second example, a bystander yelling and cursing at an officer for how they're treating somebody who's being arrested. Guess what? It was loud. It was unreasonably loud, perhaps, but it's also political speech that we want to protect, not disorderly conduct. Now, the third example, a man is pulled over for DUI, and he's so mad at the officer. He's yelling, he's cursing. You got better things to do. I can't believe you're harassing me. You guys are being jerks, yelling and screaming. So much so that an uninvolved person stops what they're doing. They call 911 because they're worried about the police officer. Guess what? That is disorderly conduct. They're way too loud where it actually interferes with somebody else's right and enjoyment of privacy. So disorderly conduct for being unreasonably loud, it gets complicated really fast. So complicated that you actually don't see this charge too much. Because as soon as it starts being a criticism of the officer and how they're treating the person being arrested, it jumps to this level of constitutional protection. And, you know, it's a jury question. At the end of the day, if a person asks for a jury trial, it's a jury question. And it's a lot of effort, a lot of work for a misdemeanor. So you don't typically see the unreasonable noise part of disorderly conduct charged too often. It does happen though. And with the body cams, it can oftentimes be pretty clear if someone's just being a loud jerk versus being mad at how officers are treating them. So keep that in mind. And you never want to be the person yelling and screaming, acting like a crazy person, unless there's a good reason for that. That will actually be fantastic. Hey, you abuse, hands up, don't shoot. Don't hurt me. I'm not resisting. Those are great things to say because that implies to the officer you're not a danger and it's political speech. Now, there are two instances where disorderly conduct can become a felony. And the first one is disorderly conduct at an airport and it messes up security or impacts security at the airport. The second one is causing a disruption at a funeral, and the disruption actually impedes or adversely affects the funeral proceedings. So those are the two ways disorderly conduct can become a felony, pretty self-explanatory. Disorderly conduct is a crime, and sometimes it's called breach of the peace. I don't really call it that too much, but it is serious. 6 months in jail, $1,000 fine. Usually you see it with other things that are charged, but it's serious. If you have any questions about disorderly conduct, give me a call, 317-632-3642. Love to talk to you about disorderly conduct or any crime. And most importantly, remember to always plead the fifth.